Good day. Thank you for joining our live webinar. Today's topic, Unopposed Divorces Unpacked. If you are watching this video later, when we are not live, that's also very much appreciated. Let us begin. Many people do not understand the concept of an unopposed divorce. Some people are of the view that you can divorce someone, at least in South Africa, they are of that view. You just sign a document and you file it at court and then you are divorced. Unfortunately, the South African legal system does not work that way. There is a process for every divorce to take place, a legal process. It entails summons being issued, served upon the other party. One of the parties have to attend court and give evidence, even if the divorce is agreed upon. That's very important to note. A legal process has to take place. And in today's webinar, because of all those misunderstandings, I would like to, in a very short span of time, explain to you and unpack for you how an unopposed divorce works in South Africa. If we're dealing with opposed divorces, in the sense of where the parties are not agreeing to the terms of the divorce, that is a extremely long process, complicated, and if you make use of lawyers, can be very expensive. Many steps that are mentioned in this process of an unopposed divorce or an undefended divorce are not, or for lack of a better way of stipulated, this is an abridged way of divorcing, whereas an opposed divorce might have another, let's say, 30 or 40 steps that may have to be applied. Nonetheless, let us proceed with today's topic, Unopposed Divorce Unpacked. First and foremost, a divorce would not be unopposed unless both parties agree to the terms of the divorce. If, for argument's sake, the parties agree, yes, the marriage has broken down, wife or husband does not want alimony, personal maintenance, they even agree that the minor child should live with the father. The father can have primary residency of the minor child. But the issue of contention is the amount of maintenance the mother must pay the father. Because of that bone of contention, unfortunately, it is not an unopposed divorce. It would become an opposed divorce where the entire process has to follow. There'll have to be discovery, pre-trial meetings, a lot of things still has to take place if the divorce is opposed. Therefore, even if it's one item, it will have to be adjudicated upon in the court. But with regard to maintenance, it sometimes happens where the parties agree to leave that specific issue to the maintenance court. So they say, yes, we have agreed upon all these 9 points, but point number 10 being maintenance, we meet each other halfway and we agree upon this amount, but the one party reserves the right to approach a maintenance court for a different amount. But that's a simple example. But usually the parties could, or for a better way of saying it, it is possible that the issue could not maybe be maintenance. The issue could be what time the other party will have contact on a Saturday. So they agree upon everything, maintenance, care and contact, the property, and so on. However, the father wants to have the minor child with him every Sunday to take the minor child with him to church. And the mother disagrees where that is concerned. She has no problem with the father having contact with the minor child, but after church, because she wants to take the minor child to church. I'm using a fictitious example here. Because of that, unfortunately, there would not be a settlement agreement, and the divorce cannot proceed as an undefended divorce or an unopposed divorce. But let's say, in my example, the parties have agreed upon all the terms of the divorce. They've agreed that the marriage has broken down. They agreed that neither party would claim alimony, or they agree there would be an amount of alimony applicable. They dealt with issue concerning the pension fund, the debts of the joint estate. They've discussed all these things, and they have reduced it into writing with an attorney, an advocate, or themselves, and they have come to this agreement. This is how we are going to dissolve this marriage, this partnership we had. Now we have one estate, and now we'll have two estates after divorce. Or they might have been married out of communal property, with the accrual, without the accrual. They may have kids, they may not have kids. But they have come to an agreement. The marriage has broken down, first and foremost. And remember, it might sound elementary, but we cannot divorce people who are happily married. There should be problems in a marriage. They have concluded, they have agreed upon everything. Wonderful. Now what needs to be done for an unopposed divorce process to take place? They have to decide who will be the plaintiff and who will be the defendant. Because, as mentioned early on, you cannot both sign a document and say we would like to get divorced, and someone files it at court and the judge just rubber stamps it. It does not work that way. The divorce process is still an adversarial process, even if the parties agree to it. Because how does a judge know the parties agree to that? He might see a settlement agreement being signed. How does he know that signature is your signature? How does a court know that you have been served with this documentation, the proper person has been served, or that you're agreeing to all of these things? It's possible for one party just to say, oh yeah, I attach a settlement agreement signed by my other party, but this party was not even served with a summons. So even if you agree upon the divorce with the other side, the summons that is being issued still needs to be served upon the other side. And the other side should still have the opportunity to decide to defend the matter or not, despite him or her having signed a settlement agreement. Because what if he didn't sign it? It's fraud, for argument's sake. So we'll start the process as follows. We'll draft a settlement agreement, dealing with all those aspects I've mentioned earlier on. Property, parental rights, alimony, debts, whatever the case may be. Pension fund, the clauses must be stipulated there in the settlement agreement. If one party would be obtaining pension, half the pension of the other party, it needs to be stipulated in the divorce agreement, in the settlement agreement. Let's say you've done all of that. You will draft a summons. A summons is basically a document issued by the Register of the High Court or the Divorce Court, the Magistrates Court, basically informing the other party that an action is being instituted. There's a case number over there, there's a stamp of the court, and attached to the summons would be a particulars of claim. Now, particulars of claim is a document whereby you outline what your case is. So in a divorce matter, the first thing, or in any action or any court case, you'll have to mention who you are. So I'm the plaintiff, this is who I am a doctor, I am a nurse, I'm a teacher, whatever you are. I'm a business person, I'm unemployed, housewife, and who the defendant is. The defendant could be a computer technician, unemployed, doesn't really matter, but you need to cite the defendant or the other party. Then you go on and you stipulate that the parties live within the Western Cape. You consider the Western Cape as your home, or Gauteng or Johannesburg, in order for the court to have jurisdiction to deal with this matter. You have to live within the court's area of jurisdiction in order for that court to divorce you. There are of course some exceptions, and not one of the parties at least has to reside within the area or jurisdiction of the court. Then you go further. Then you inform the court, okay, we're dealing here with a divorce matter, so you inform the court that on a certain date, you and your spouse or the defendant married in community property, out of community property, whatever the case may be, and you mention the date and the place. And you attach your marriage certificate. So we have evidence here. So number one, we've determined that these are the parties, that they live here, or one party lives here. And number two, or number three, that they are married. Very important. So the marriage certificate basically shows that, a copy of the marriage certificate. Great. Then we deal with issue concerning minor children. If the parties have minor children, you mention that. If there are no minor children involved, you say there are no minor children involved. And you might want to mention that the parties believe, or the plaintiff believes, that the parental responsibilities and rights of the minor children would be best as outlined in the settlement agreement, which is attached and referred to it later. So that's fine. But now we determined a few items, a few points. We outlined it, we unpacked it. Now we need to get you guys divorced. I mean, that's common knowledge. We know you are kids, we know you're married. No court will divorce you if you are happily married. So you have to make those allegations. Then you stipulate that the marriage has broken down irretrievably, the marriage cannot be saved, and these are the reasons for that. So you say there's no love and affection, you guys are living separately for the last year or two, you do not want to be married with the other party is abusing alcohol, other party is having affairs. That's what people like mentioning, or they mention it. I'm more focused on the issue concerning the marriage has broken down. You stipulate that, and you say the parties are incompatible, there's no love and affection. I think that should be enough. You do not have to air all your dirty laundry. It does not mean that you are now airing all this dirty laundry to the world. The court will grant you the divorce more speedily, or you have a stronger case for divorce. I mean, if the marriage has broken down and you come to court and you stipulate that in an unopposed divorce process, the court will grant you the divorce based upon that element. And then you say the marriage cannot be saved. That's the bottom line. Then we go further. You now have to close your pleading, your particulars of claim, and you basically stipulate that I would like the following. I would like to have a decree of divorce, and that the consent paper which is attached here to, or the settlement agreement or the parenting plan attached here to, that was entered into between you and the other party be made in order of court. So that's in a nutshell a general way on how these court documentation are laid out and presented to the court. Let me just explain to you one step further. If this matter is an opposed divorce, the other party would obviously have a right to plead to that. And he will say, at paragraph 1, he say, I agree that you are married, I agree that there are so many kids involved, but I disagree regarding that the primary care in this draft parenting plan is in a minor child's best interest. So you will be able to respond to that. Or the clause stipulating that you are an alcoholic, the defendant can say, I deny that specific clause, I'm not an alcoholic. And then the defendant would have an opportunity to file a counterclaim to that, whereby he will stipulate what he wants ultimately at the end of the whole process. So that's if the divorce is opposed. So that's a different process that will be followed. But in our example, everything has been agreed upon, and there will be no issues at the end of the day. Okay, so you have the summons, you take it to court, the court will sign it, the registrar will sign it, all the documentation are attached to it. You will also file an annexure A. It's basically a document that gets filed with the Office of the Family Advocate, your details, the kids' details, and so on. And that specific document will now be taken to the sheriff's office, and the sheriff will now serve that document on the other party. So you can see here in my notes on the whiteboard, yeah, that's it. It will be served upon the defendant. Despite the defendant having signed the settlement agreement, he or she will now have to be served with a summons. The defendant would have a period of about 10 days, 2 weeks, 10 court days to determine whether or not to defend the matter. Of course, more than likely he or she will not defend the matter because he or she agreed, you guys agreed upon this divorce process to be finalized. But he or she still has an opportunity to decide whether or not to oppose the divorce. But let's say the 10 days passes and nothing has been done by the defendant. Then you obviously can set the matter down depending upon the court, how busy the court is. You set the matter down and you advise the court, this matter is unopposed now, nobody's opposing this divorce, and the 10 days has expired, please give me a court date. The registrar, in simple terms, will give you a court date, and you will obviously, you don't have to, but inform the other party that this is a court date when the divorce will take place. Then before that court date, obviously you'll ensure that the court file is in order, the summons is in the court file, the return of service is in the court file, all the other documentation that was served upon the other party would be in the court file. And then you appear in court. This is where the court will now have to make a decision, or where the court will now listen to evidence and decide whether or not to divorce you or not. So let's say you're number 10 in the queue, and you saw the other people, how they done their divorce, so you'll learn a bit and you'll become a bit more confident. But basically, this is how it goes. Your matter gets called up, you stand up, you say you're the plaintiff in this unopposed divorce matter. You'll say that your papers are in order and that you are available to take the prescribed oath and to testify, or you wish to testify. You'll go on the witness stand, the registrar will swear you in. Do you swear to tell the truth, the whole truth, but nothing but the truth, so help me God? You will say yes, how you do, and then you'll present evidence. You'll start as outlined in the particulars of the claim, that this is who you are, this is a defendant, you are married on a certain date, there are so many kids involved, or there are no kids involved, the marriage has broken down, and these are the reasons why. And ultimately, you also call that to like a decree of divorce incorporating the settlement agreement that has been granted. If the court is satisfied that the marriage has broken down and that the documentation was served on the other party, and this is a settlement agreement, and you confirm the signatures of the parties, the court will, based upon that evidence, grant a decree of divorce, dissolving the marriage between you and your spouse. That's it. An unopposed divorce unpacked. I might have left some things out, some minor things out, but that's not really relevant here. If the divorce is opposed, obviously it's a total different ball game, a total different type of scenario that will apply, and it would not be this simple. Therefore, I advise many clients, please try to have a divorce done unopposed, because if you are married out of communal property, there's nothing to argue on there. If there are no kids involved, there's nothing to argue over there. What are you guys fighting over? If there are kids involved, still try to have it unopposed. Maybe have an expert mediate the issue, try to resolve the issue concerning primary care. But of course, if you guys cannot resolve it and you believe that your view on the matter is in the minor child's best interest and the other party believes so, unfortunately, only a judge can finalize that, can adjudicate upon it, and he will make he or she will make a final decree of divorce based upon the evidence presented. But it will take a long process, a long time to be finalized. Have a lovely day, and I hope to see you online again soon.